Good morning, everybody, and welcome to you all this morning. It's brilliant to be back with another session of ASSC Talks. Delighted that so many people have registered for today's session. So as we all know, in the wake of the pandemic and to some extent Brexit, there's been a huge reliance across all industries on their terms and conditions in terms of delays and cancellations of projects and services. And that, of course, applies to the hospitality industry as well. And the terms and conditions you present to your guests should protect your business from additional cost and liabilities and ensure that you have clarity with those that you're contracting with. I'm absolutely delighted to be joined once again by Joanna Miller, Legal Director with Gilson Gray. Jo is a qualified over 25 years and during that time has specialised in licensing and corporate law. Prior to joining Gilson Gray in November 2019, Jo ran her own firm. Her team moved over as a whole to Gilson Gray, so this background allows her to understand not only what she's doing with Gilson Gray, but understand firsthand the challenges that face owners operating small and medium-sized businesses. Just to let you know, the session's being recorded and we are going to publish it later, so you can go back to it if you want to pick up any of the detail. And also, don't forget, do put any questions in the chat area and we'll have a Q&A in a little while after the presentation. Cancellations. Pre-COVID, they were incredibly unusual. I don't think I ever had one in 17 years of operating. Now it's just part of life. Something we should all consider to be part of the new normal. I do hate that expression. But it's something we have to deal with. Guests now have a real appetite for reassurance when it comes to their bookings, and it's something we need to pivot our businesses to accommodate. There's little doubt at all that flexible cancellation policies will now be much more appealing, and it's unlikely that this is going to change in the foreseeable future. COVID's still with us, and we've got no idea what else is around the corner. So it's time to revisit our cancellation policies, and it's time to look at our terms and conditions to cover all eventualities. Just a bit of background. The Competition and Markets Authority, the CMA, ensure that businesses treat consumers fairly when, in our case, accommodation booking arrangements are impacted by COVID-19. Initially, at the start of the pandemic, the CMA took the position that consumers affected by the first COVID-19 lockdown would be entitled to a refund in all circumstances, and that any terms and conditions that provided otherwise would be unfair and therefore invalid. I think we're all aware of that fact. Moving beyond these unforeseen events to a world where guests, owners, and indeed agents are aware of the ongoing impacts of the pandemic with associated restrictions and self-isolation, all the other fun stuff that goes with it, the CMA has amended its guidance slightly. In the simplest of terms, for holiday accommodation, the service is the provision by the owner of the holiday accommodation. There's been a lot of discussions about contracts for accommodation having been frustrated due to COVID-19 restrictions, and the CMA guidance attempts to summarize the legal concept of frustration and states that a contract will be frustrated as a matter of law if, due to no fault of the parties, something happens after the contract was entered into, which means it can no longer be performed, or at all performance will be radically different to what was agreed. In these circumstances, the CMA expects consumers to receive a full refund. The CMA's view is that if an owner or agent can't provide the holiday accommodation, then the guest is entitled to a refund. Whether a contract is in fact legally frustrated will, however, depend on the circumstances and the particular terms and conditions of that contract. And that's what Jo is going to cover in a little while. It is not the case that a contract that cannot go ahead due to COVID-19 is frustrated if the contract anticipates and deals lawfully and fairly with that situation. Where it becomes slightly more confusing is in circumstances where businesses can remain open, but for various reasons, the guest can't make use of the accommodation, whether it's them coming from an area of local lockdown or you're in an area of local lockdown. Or if guests are only able to accommodate with smaller group sizes due to household restrictions. Now, fingers crossed we're over these issues, but in both those scenarios, the contract is not legally frustrated because neither party is prevented from fulfilling its obligations. In other words, the owner is able to make the accommodation available, and the booking lead can still use the accommodation, even if they're disinclined to do so, given the change in circumstances. We've always recommended that guests have taken out travel insurance to cover any circumstance that arises preventing them from traveling, whether that's illness or accident, missing a flight, or being called to serve on a jury, whatever it is. There's no reason why illness from COVID-19 or the requirement to self-isolate or household restrictions or all of those other things should be treated differently. Those are not risks that an owner should reasonably have to take. So the big question is, how do we protect ourselves going forwards? We need to be absolutely clear in our terms and conditions so that we're protected. And in fact, the guest is protected from any surprises. So Jo, I'd love to welcome you again today, and it's over to you.
Morning, everyone. So just checking that I'm actually not on mute and my video is on, as the usual issues which befall us in these things. So interesting points there made by Fiona, and a number of things perhaps to pick up from that. Maybe just a precursor. I know a few of you are already saying that style terms and conditions would be useful, and while I understand why, I'll come on to that as style terms and conditions are not always what they seem, and they're not a benefit if they don't cover everything, and you all run very different businesses. So first of all, just picking up on what Fiona said about frustration, and it is very important. The difficulty is that sometimes guidance on this kind of thing is very difficult because frustration has to be considered on a case-by-case basis. And while there are issues with, for example, if you're unable to offer the accommodation, as has been the case during lockdown and similar, there is a limited interpretation perhaps for the guests and whether the guests are able to attend. So one of the things I'll cover in this talk is considering coronavirus terms and conditions and what you might want to include in them. In terms of general terms and conditions are very important. And some of you may think, well, why is that? Since lockdown, as Fiona said before, there have been more cancellations than ever. And some of those has come about because you have guests who are unable to attend, and some of that has come about because you are unable to provide the accommodation, either because of your personal circumstances or because of government restrictions. That means the terms and conditions you have need to be clear, but they also need to be accurate. So they need to be clear on what happens if there's a cancellation, not just for you, but also for your guest. I think it's important to remember that there are other things still affecting us other than coronavirus. So there are various other things which we need to consider, and that is the normal day-to-day cancellation issues which may have been around, and illnesses which may have been around prior to coronavirus, which we will still have once coronavirus goes away, and hopefully it will at some point, and it will fade into the flu or something similar, rather than being the issues it presents today. Although we would hope guests did not cancel without proper consideration, a lot of cancellations have been out with the control of both you and the guests, and we therefore do need to provide for that in your terms and conditions, setting aside coronavirus. And perhaps there's lessons to be learned, and I understand there was a master policy which is not available now, and I saw someone in the chat asking if there was a replacement to that, but in the absence of that, it is really important for you to consider what impact cancellations have on your business. So in terms of terms and conditions, starting at the most obvious, perhaps, point of terms and conditions need parties. They need two sides to enter into the contract. The person who is giving the service, the accommodation, and the person who is taking the service. This is not always clear, and even if you are clear on who the parties are, this has to be clear and consistent in your terms and conditions. So if you have terms and conditions, it is important that this clearly defines who both parties are. And that may sound very simple, but hopefully you'll see why sometimes it's not. One of the other fall downs is that terms and conditions sometimes use different terminology throughout it. This can lead to confusion, and it could lead to an inability to be able to recover based on the contract. So there are two main bases in Scots law in which you can recover: contract and damages. If somebody breaches your contract, then you potentially have a claim against them. If your contract is not drafted properly and they are able to say that they weren't clear on what was in the contract or who they were contracting with or various other matters, the court may accept that, and you may find yourself with a damages claim instead, which would only be a claim based on your loss, and not all of that loss might be recoverable. So it is better and necessary that your contract is clear, and that means using the correct terms throughout. So once you define who you are, stick to that. Once you define who your business is, stick to that. If you know the definition you want to use, then you need to stick to those definitions. You need to consider carefully who the parties are and what the premises are, particularly if you run different premises. So who are you? Who runs or owns the short-term letter business? Now, some of you will do this as sole traders, some as partnerships, maybe limited companies, or maybe a limited liability partnership. And it may be you are now thinking, I don't know what I am. We own this jointly, but I run it together. I run it myself, or I own it with one person, but run it with another. So it's really important to identify who is actually operating the business. And that may not be the same as the entity which owns the property. It may be a different entity. And some of you may not own your own property. Some of you may in fact rent your property and run it from there. So for example, if you run a bed and breakfast, it may be that you actually rent the bed and breakfast building and then you are running the business from there. So the owner in this case is not a party to the terms and conditions. Different business entities do give you different benefits, and this is where I suppose my corporate background comes in along with licensing. So you need to consider when you're running your business whether you want to have limited or unlimited liability. And that's important to consider before you finalise your terms and conditions, because in that you need to state which entity is contracting with your guests. So a sole trader and a partnership do not have limited liability. Liability is unlimited. If you wanted to operate through a limited company or a limited liability partnership, then you would have limited liability. And I understand some of you are thinking, well, why would I want limited liability? Surely that's inappropriate. Surely that's not good management, or that's not transparent. But quite the opposite. And one of the things which the last 18 months has taught us is that we need to be planning for unforeseen events. And as a business operator, you need to be looking at your entity and your operation and putting that in place before you then go forward and look at your terms and conditions and your guests. So who are your guests? And again, this may seem terribly obvious, but in fact, it's not. It's a fact that the person making the booking is not always the person attending. Maybe gran and grandpa are coming, but they're not very good online. And so granddaughter helps them make the booking and she pays it on her credit card. Maybe it's a surprise for somebody. So the person making the booking makes it, but the person who is actually going to be in attendance doesn't know anything about it until a couple of weeks before. So the important thing here is in your terms and conditions, we need to identify who your guests are, but also who you're contracting with in the first instance. You then need to consider whether the person you're contracting with in the first instance can be made responsible for the guests if that person is not even going to be there. So this comes down as well, not only in the contract, making clear who the guests are, so who's physically staying with you and who you're contracting with in the first instance, but it also means making sure that everybody who will be staying in the property has had sight of the terms and conditions, or takes responsibility as the lead person for making sure everybody else is aware of those terms and conditions. And that's important if there's any day guests and whether you allow day guests or not, because it may be you don't want people visiting who are not staying there. It may be you're happy with that, but you want some form of contact information from them. And that's perfectly reasonable to ask for, despite any track and trace or NHS app. If you want to know who's in your property, it's your property and it's a commercial property. So you are entitled to ask, even if your property is not registered for rates and it's on the roll and under council tax, this is still your business. So you are perfectly entitled in your terms and conditions to state restrictions on people whom details you have not been given staying or visiting the premises. So unfortunately, we are not going to get through a presentation without talking about coronavirus. And even though it is leaving us, and even though it is something which we're hopefully, as Fiona said, the new normal, albeit it's not an ideal phrase, we are coming hopefully to the end of something. But the fact is it's still around. And the fact is people are still getting the virus, and there is still provision in place as to what needs to happen when someone does find that they've tested positive. So you do need to consider that. If, as Fiona said, you are unable to provide accommodation for some reason, then you need to carefully consider whether that is frustration of the contract and whether at that point you do require to give a full refund. That can be provided for in your terms, but this is where, again, standard terms and conditions perhaps do not work, as each person will be in a different situation. If you were to test positive for coronavirus and you are operating this business entirely by yourself, then it may be you are not able to provide the accommodation and you need to cancel on that basis. If, however, you have tested positive for coronavirus, but somebody else is able to assist you, then it may be you can carry on running the business and carry on offering the accommodation. So that is why the frustration has to be considered on a case-by-case basis, but terms and conditions also need to be considered on a case-by-case basis. In terms of coronavirus, there are various things to consider, and I'm sure all of you have probably either experienced or considered these. But the main things is, in the first instance, guests attending. You're perfectly entitled to insist guests should carry out a flow test before attending and that they should provide confirmation to you of the result. Not everybody goes online and logs their test result, so it may be a step too far to insist upon that. But if you wish to do so, then it's certainly something you could put in your terms and conditions and then take a view if a guest refused to do so. However, as I've said, you can insist guests should carry out a flow test before attending and should at the very least intimate the result to you. If there is a positive flow test, then a guest must have a PCR test before coming to the property. So they should have the full test to make sure that if they have a positive flow test, they know for sure whether they're positive. Sometimes people might do some more flow tests, but the only way of being sure is by going and actually getting an NHS test. If, as a result of this, then the guests are unable for all or part of their stay to attend at the premises, you then need to take a view on what you refund. And the issue is, if somebody has a flow test, it's probably been done very, very close to their stay with you. So it's probably something which has been done a few days or 2 days before they come. On that basis, it's most likely they have now paid their full balance, and you need to consider as a business what you want to do. Do you want to refund just deposit? Do you want to refund everything but deposit? Do you want to refund a percentage, or are you not prepared to refund at all? And in terms of frustration of the contract, one of the things Fiona mentioned was whether the contract is frustrated depends on whether there are terms and conditions in place and what they say about this. If you decide that you are going to refund, then again, you need to stay in the terms and conditions up to what point and what percentage, if that's everything except the deposit, or if you're doing a breakdown of that. If only part of the party are able to attend, then the fact is that it's out with your control if somebody is unable to attend and the accommodation is still being used. If you wanted to consider a reduction or some kind of refund, you can, but strictly speaking, if the party is attending, even if some members can't attend, then it would normally be the situation where you would not be expected to refund. There's then the question of what happens if someone tests positive while at your premises. So if somebody has symptoms, then they should immediately be advised to take a lateral flow test, and that should be in your coronavirus terms and conditions. If they then test positive, they should then get the full NHS test, and they and anybody who's been staying with them in the property should self-isolate until the results of that test are available. You should also, in your terms and conditions, refer to any action which people should take during that time. So there should be a contact number. They should be able to tell you or whomever the contact is for them during their stay at the property. If they have any deliveries coming or any orders, for example, from a supermarket or similar, then they should take appropriate steps to advise them, either explaining from a distance or putting a sign on the door or something similar. So there should be some obligation on them to act sensibly and in keeping with the Scottish Government guidelines. If they then receive a negative test, they are able to carry on as normal. Other guests who have been in close contact with them would also be advised to take the full NHS test. If they decline to do so, then you may wish to consider why, but you would want to ensure that the terms and conditions refer to you being kept in the loop with what is going on if there is any suggestion that there has been positive tests. Guests may not have lateral flow tests with them. They're on holiday, so I suspect it's perhaps not their main concern. If there is a lack of lateral flow tests, these can be obtained locally, and there is currently no charge for them. Were a charge to be brought in, you might want to include that in your terms and conditions, but at the moment, given there is no charge and they're fairly easily accessible from your local chemist or online, it may be advisable to have some of these available so guests can use them either on request or in with the first aid kit or similar in the premises. If someone tests positive while at your property and they then require to leave, it should be made clear in your terms and conditions that that is the position. They cannot stay in your property, they will have to go. This has created something of an issue because not everybody will be able to travel in private transport, and there is still a requirement that people do not go out and do not go on public transport. If somebody really cannot get any form of transport away from the premises, then you would have to contact your local council, and they should have emergency accommodation available where people would be able to spend their time and isolate for the period of their illness and for the required period. One of the issues, of course, is that this is constantly changing. So it is, as we say, a movable feast. Currently, the period is 10 days, but that may change. And therefore, it's important for you as an operator to keep abreast of this. What is also important to keep abreast of is what you can do in relation to travel. Now, at the moment, there are no travel restrictions, and we are hoping that within the UK, these will not come back in. There are obviously travel restrictions on other countries, so where we can travel to and who can travel to us and what steps have to be taken. There is some obligation on you to keep an eye on the traffic light system, the green, amber and red system, which the Scottish and indeed UK government have put into place. So you do need to put something about that in the terms and conditions, but there is no point listing all of the countries as these change so regularly. So my advice would be that there is a separate, we do have a style coronavirus set of terms and conditions. And if you were to use them, for example, the advice would be that you then keep an eye on any changes to legislation, any changes to guidance, and also any changes to which countries are in which of the green, amber, red. As an operator, there is an obligation on you to ensure that someone coming to you from a country which may be on one of those lists has gone through the relevant requirements. Now, I appreciate that is incredibly difficult because people may come in and they may lie to you. You may want to ask for a boarding pass or something similar to see when someone arrived. You may want to ask for a travel ticket. How far you want to go is up to you. There is an obligation on you as an operator to take some steps to ensure that people coming into the country and staying with you are meeting the regulations, just as there would be if you had friends come to stay from abroad. But at the end of the day, it is the individual who needs to be taking the correct steps, and any enforcement of that really needs to be done out with you and your contract with them. So while it's advisable to refer to this, it is not really advisable to make too much of an issue. And you also have to be careful not to stray into breaching GDPR and asking someone to produce information to you, which in fact they shouldn't be required to do so. So in relation to terms and conditions, we've skipped through the parties and we've looked, unfortunately, at the coronavirus aspects of this. As I've said, it's important to make sure that the terms and conditions are clear, that the definitions are at the beginning, and that the definitions are correct. So whomever is the operator, for example, is the party contracting with guests. You need to identify your guests and how you split the person who contracts with you in the first instance from those who are actually attending at the premises and staying, and additionally, any day visitors or other guests who are not perhaps originally part of the plan, but rather who arrive or who come even if they don't stay over. There are some other issues which have come up recently in discussions with short-term let operators. So some of them is around same-sex groups, and you do have to be very careful when you're taking a view on what you wish to do, and if you perhaps don't want to have certain party groups coming to the premises. Particularly with the proposed licensing scheme, one of the issues which it stresses throughout the guidance and throughout the statutory instrument, which is bringing in the proposed new legislation, is that there is an issue in relation, perceived issue perhaps only, in relation to neighbour complaints, noise, nuisance, and other uses of short-term let accommodation. From that point of view, if you feel that your accommodation isn't suitable because it is located in a rural quiet area or has elderly residents around or nearby, then you can decide that you don't want to accept, for example, 18th birthday parties, stag or hen nights. That is perfectly acceptable, and indeed you'll find many licensed premises won't give their function room out, for example, to 18th birthday parties, because the identification required, the number of stewards required, and the general oversight required makes it far too difficult for them to operate and run the other parts of their business. So you are entitled to say that you perhaps don't want stag and hen parties. What you do have to be careful about is the phrasing of that. And we must make sure that, even though I have no doubt none of you would intend any form of discrimination, you must make sure that there isn't any form of discrimination in your terms and conditions. You do, however, have a discretion, and if, for example, a very young group of persons booked but said it wasn't a hen party, then you might feel that before you accepted the booking, if there was no, perhaps they were young adults and there was no more mature adult in the group, it was something that you didn't want to accept a booking for. If you don't want to accept a booking because it doesn't suit your time scale or you're trying to go on holiday, then again, that's perfectly acceptable. That also means that you need to be careful at which point you have accepted a booking. So you need to make sure that your terms and conditions are clear as to when your booking is accepted. So that's not when somebody makes an inquiry. That's perhaps also not when you respond to that inquiry, because you may have responded saying, yes, we are free, but that person's taken a week to come back for whatever reason. And in the interim, somebody else has come, asked about the same period of time, paid their deposit, and the booking period is now no longer available. So you do need to make sure, and this goes back to communication, that you're clear in your terms and conditions and you're clear within them and with your communication with potential guests at what point a contract is actually agreed and the booking is actually accepted. And that leads on also to how you communicate your terms and conditions. So they should be on your website if you have a website, or on your Facebook or other social media if you have that. But not everybody has access to websites or social media. Sometimes that's by choice, and therefore you do need to be able to present those terms and conditions to people in other ways. If people are calling and they genuinely have no email and no ability to go online, then you may want to ask if they have, again, their granddaughter, going back to my first example, or somebody else in the party who might be able to accept information by email. If that's not possible, then you need to post it out. But you should make sure that there is clear reference to your terms and conditions. And when you're corresponding with people, that your terms and conditions are at least referred to in the email, either with a link to a website or other social media place where they can be found and opened and easily read, or that they are actually attached. And sometimes people will have a summary of their terms and conditions on their email if they don't want to attach the full thing, but you should certainly have a link where possible. Going back to the question of discrimination, there is also then a question of guide dogs and assistance dogs. I know certainly of some ASSC members who do not allow dogs at all. So dogs are not allowed on the premises at all. And while some of you may say, well, you just can't do that, there is an element that you can do that, but you must be able to justify it if questioned. So if perhaps where your premises are located in terms of wildlife, where you don't have fences, for example, and if dogs were allowed to run free, then that would cause an issue. Then you could potentially restrict dogs or other animals, and you could potentially restrict dogs to being on the lead only. You could restrict it to guide and assistance dogs. I do know of a couple of premises who do not even allow guide dogs or assistance dogs, and their basis for doing that is they have never done so. Therefore, their accommodation is allergy free. So for someone coming who has an allergy, their position is that is really important to them and their existing guests. But unfortunately, although you may accuse me of just taking a lawyer's stance on this, as with frustration, a lot of that needs to be considered on a case-by-case basis. So you need to take a view, but you may find that view is challenged. If that view is challenged, you need to then be able to justify that view. So that's another reason why standard terms and conditions don't work, because you need to be able to consider your position, your view, and the justification for that. So if you're called upon to say why you didn't want a group of young persons or why you wouldn't allow dogs, then you need to be able to justify that. One of the other questions which has arisen predominantly into the proposed licensing scheme, and while I understand it's not in yet, it is one which I have, despite general concern about the scheme and the cost, etc., been asked, is the inspection period. There is some proposal that there will be a requirement to allow council inspectors to come out to the premises at any point in time, and that creates an issue. But it also flags up something which is useful to consider, and it's something which I've been advising landlord clients on recently in relation to being able to inspect your premises. So you should also consider in your terms and conditions some inspection provision, so that if you want to be able to go into the premises, you are able to do so. You do need to give fair notice, unless of course it's an emergency. So for example, if you see flames coming out the premises or water pouring out the premises, or you can visibly see that there's been some damage and there's perhaps a roof slate missing and a leak, then you would essentially be able to use emergency provisions and go into the premises with very little or no notice. But again, that's something which in my experience tends to be missing from terms and conditions, and something which I think you should consider. So from that point of view, I appreciate that we've not covered perhaps nearly half of your terms and conditions, but there is far too much to cover in just one seminar, and I don't want to send you all to sleep. So I'm happy to answer any questions. I'm happy to answer emails. I'm sure my details are on the SAC website, and I'm happy to talk you through again the issues in relation to sample or style terms and conditions. And from the point of view that so many of you operate differently, and you operate everything from a room or part of your home, a bed and breakfast, or a full self-catering unit, standard terms and conditions don't work. And the problem with them is that while you can download them from online, they may contain English provisions which are not relevant in Scottish courts. And you may then find yourself back in the position we discussed at the beginning, which is if your terms and conditions are not accurate, then you may not be able to rely on them. So from the point of view of terms and conditions, as most of you already have them in place, my advice is don't swap out what you have probably worked up to over years of operating, but instead take that as a base and consider and amend that, because that will have in it a lot of the terms and conditions that you are comfortable with, that you have developed, and things which you have thought about which are unique to your business. Thank you, Fiona.
Jo, that is incredibly helpful. It sounds slightly daunting, if I'm honest, as an operator myself as well. But at the same time, you've given such amazing examples, and it's not all COVID driven, which was really lovely. Thank you so much.
Yeah, it shouldn't be daunting. It can sound daunting. It doesn't sound daunting to me because I do this every day. But what would sound daunting to me is having to make breakfast for 20 people in a very short period of time. And I think if somebody said you have to now go and change and replace, a dozen beds, I might just cry. But all of this doesn't seem daunting. So I think the point is that this is what I do. You guys do what you do. And there's got to be a crossover for you to get advice and to rewrite these. And it's just a case of looking at them. We have a kind of rough workup of depending on how long your terms and conditions are, based on Arial point 12, for example, taking off any signing part, then we can look at revising them on a fixed fee basis. So if they're 2 pages long, 4 pages long, if they're 10 pages long, I think I might be saying to you they're a bit too long. I think I might be taking chunks out, or your guests will have fallen asleep reading them before they've even got to the end. But there is always a sensible middle ground. And I know it might seem daunting, but it's a little bit like writing a will or arranging that house insurance or car insurance when it comes up to expire. And once you do it, you'll feel better, and it's done and out the way for at least a period of time.
You're right. And actually, as we said at the beginning, this has been recorded. We'll also provide a transcription of this session, because it's so useful, and people can go back and look at the details, things about the dogs, and all those little details are really important. So it's been so helpful. We've got some really, really useful, sensible questions here for you, and I'm hoping that you're going to be able to answer some of them. One is, can you send revised terms and conditions to a booking which have already been made, and not just to future bookings? That's really actually quite relevant these days.
Yes, you can. You can send out additional and revised terms and conditions, but it would then be up to the person if they wanted to take the booking on that basis. So, for example, because of the current position we find ourselves in, sending out coronavirus terms and conditions as an addition shouldn't be an issue. And as I said, we have terms and conditions for coronavirus as a standalone, which I'm just about finished drafting. And we were sort of hoping on some feedback from Scottish Government, but as Fiona and I know, that's not always forthcoming, and they're very busy with other things. So I'm hoping that they will be ready to be circulated shortly, and probably this week. But they try to cover most of the matters which you should consider as an operator. But they're very much standalone. So sending them out to somebody that already is booked with you, I think would be not beyond criticism, but there shouldn't be anything in them which was going to cause somebody an issue, because it's here, we need to deal with it, guests need to deal with it, operators need to deal with it. What you're doing is reasonable. If you change terms and conditions so radically that somebody was very unhappy with that, then, for example, they may say they don't want to attend. So if maybe they had said, we're booked in, but my sister wants to come and stay for a couple of days because it's my birthday, and you'd said that's fine, but now you're saying that's not fine, then that might be something which causes them an issue. So yes, you can send revised terms and conditions to someone. You need to make sure that you point out they are revised and that there are differences, so that person is clear. And if possible, you should point out at least the main revisions. So if there's something which is quite radically changed, or you've added in, or you've changed a timescale, or perhaps a percentage refund, then try to have a bullet point in your email or letter that you send explaining what it actually is that you have changed in your terms and conditions. You don't need to do War and Peace, but you should note that they're different and roughly what you've changed, and try not to do it too close to that booking if at all possible. Or if you're changing your terms and conditions and you have a booking coming in the next week, talk to them, email them and say, we've changed your terms and conditions, these are the differences, I appreciate you're just coming to us and this might be very short notice. Offer to honour the old terms and conditions, particularly if there's not a great deal of difference.
Perfect. An easy one for you. Is there a contact at Gilson Gray who can check the current terms and conditions and advise if they're adequate? That's you, right?
Yes, ta-da, that's me. So if you need to, we do have other people. We have been able to use other staff members in the corporate department, so it's not just me. But yes, I'm your main contact, and I'm happy to chat it through with you first for 10 minutes without charging anything. It's not a case of as soon as you pick up the phone you're being charged. So more than happy to have a chat with you, and then once we see your terms and conditions we can confirm a fixed fee, and it will be a fixed fee, because obviously it's something you need to understand, we need to understand, and we'll look at it from that point of view.
And that's a real benefit for being an ASSC member as well. So we're delighted to be working with you on that. Thank you. There's some other good ones here. This is an interesting one. As owners, we live in England and run a business from home, and the holiday home is in Scotland. Do we operate under English or Scottish law, or a combination?
Because the accommodation is in Scotland, you would be governed by Scottish law. So, for example, coronavirus would be Scottish government regulations. It may suit you to have the contract under English law, so that would be up to you. Because you're based in England and payment would be effectively made to you in England, then you could say that any dispute is under English law, which is better for you because it's your local court. But you may get some pushback from people on that who would not want to be put in that position. But it's probably just the same as someone from England coming up to stay in Scottish accommodation and contracting. So it's really a personal choice as to what you want to put in your terms and conditions.
It's a slight minefield, isn't it? This one isn't strictly terms and conditions, but it's something you could put in your terms and conditions. It's about the rules for getting home. If your guest has been staying with you and they get coronavirus symptoms, are they now being told to make their way home? I've checked this morning, and CalMac is saying this morning, no, in this scenario, you must still follow the official guidelines from the Scottish government. So I suppose in that sense, in your terms and conditions, you would reference checking with the Scottish government guidelines, right?
Yeah, so you would reference that because they are changing, and hopefully we won't go backwards, but who knows? So it's not possible to account for everything. That's why I'd said with the green, amber, red, also you don't want to be in a position where you're listing countries and then the next day they change. So a lot of the coronavirus terms and conditions refer to adhering to Scottish government guidance if that situation arises.
Great. Somebody else has said, and this is interesting because I don't know the answer, I don't know if you do. I read yesterday that the CMA are no longer forcing or pursuing airline companies to refund monies or to passengers when flights are not operating. Will this influence laws around refunds to self-catering?
I hadn't heard that, but in terms of self-catering, there is CMA guidance, but as we said at the beginning, each matter really has to be taken on its own merit. And obviously, I think as operators, you've always acknowledged that if you are not able to provide the accommodation, then that's different to someone cancelling with you. But going forward, I think there has to be consideration as to why someone is cancelling. And that's why perhaps you might be more inclined to give a partial refund where previously you might not have done. But in terms of the guidance, again, that changes depending on where we are with Scottish government or UK government guidance. So again, it's really just keeping up to date with the CMA guidance and seeing what they're saying on a week-to-week basis, because they will also be tracking the guidance been given by the various governments.
Fantastic. This is an interesting one. Do we need to get a guest signature that they've actually read and understood the terms and conditions, or is there a term and condition in there that you've sent it to them and they have to read it?
Generally, we would prefer guests sign, and at the moment the problem with that is twofold. People are at home, they're working from home. Perhaps it was easier when folk were in their office and could just print things and put a wet signature on it. If they are able to sign it and return it to you from a scanned version, then that might be enough. If they can sign it electronically, now I confess to not being terribly good with all of the DocuSign and electronic signatures, although we do use it in corporate work. But you could, if you are tech savvy, have something whereby it can be signed and it can be signed electronically. So an electronic signature is applied. If somebody says, I'm really not able to do that, then sending them out an old-fashioned contract and having them sign and post it back is another option. Or simply having somebody email you and say, I am so-and-so, I am so-and-so as in I am the guest, or I am the responsible person on this. I have read the terms and conditions, I've understood them, I am happy with them and accept them, and then get them to confirm whatever you require in your terms and conditions. So for example, I have circulated these to the other guests attending or similar.
Okay. It is complicated, isn't it? But anyway, we'll all be covered soon, so it's fine. Going back to the dog situation, and this is something that I'm interested in as well. My property has been pet-free for 7 years. I accept service dogs because I don't wish to discriminate, but I've never had one yet. However, I was informed in a recent meeting with Guide Dogs Scotland that there is absolutely no reason for a property like mine, i.e. in the city away from wildlife, to refuse a service, seeing a service or seeing eye dog. Any advice on that? That was the position I thought but you said that if you can give reasonable. Anyway, over to you.
Yeah, it all comes down to a case by case basis. And one of the reasons that a lot of very rural properties, I mean, I can think of one, for example, that has ducks and no barriers, and you're right on a lake, and their position is they simply won't take any dogs. And part of that is because of the wildlife that is around them. They're in a national park, and there are other considerations there. So they do not have dogs on the premises, and we've never needed to make a specific inquiry about guide dogs or assistance dogs. We've never seen any dogs there when we've been there, but it may be that they would take them if it was a one-off. Other premises, they have pet friendly and non-pet friendly accommodation. So, when you're booking, if you are booking one which is pet friendly, because that is all that's left, and you have allergies, then you need to take that on board. The difficulty is that there's no right answer here. It's all on a case by case basis. But what I would say is it does matter if you're in the city or in the country from the point of view of what your justification is. So you need to be very clear on if you would take an assistance dog and a guide dog, then you would have to be clear on why. So for example, a local pub may say that they accept guide dogs and assistance dogs, but in the same village, the local optician or doctor's surgery may say, well, there's an issue with that because you're coming into, for example, the guide dog can come into the shop but not into the examination room. You need to get a physical person to assist you in. So from that point of view, you have to be very careful, but you also have to think it through, which again is why standard terms and conditions don't always work.
So that's it. I mean, essentially, you just have to be able to justify your terms and conditions. And if you can justify them, then
to some extent, but the problem is that because you have a view, you could still be discriminating. So you need to be very careful. And what I would say is if somebody has a real issue as to why they did not want to have any dogs, including guide dogs and assistance dogs, and they wanted to put that in their terms and conditions, we would then speak to one of our employment partners who's an expert on this area and whom I spoke to about this when doing recent terms and conditions. And he was able to give advice to a client of mine, but it was very much on a case by case basis. So the problem is just because you can justify it for you in your head, you have to be very careful that you're still not discriminating. So the general rule of thumb is things like guidance and assistance dogs are allowed. If you were to say no to that, you would have to very, very carefully consider why, and that would have to really be expert advice would have to be taken on that.
Okay, really helpful. So the moral of the story is get some help with this, I think.
Advice.
I'll be phoning you later. If somebody cancels, this is interesting in light of at the moment, if somebody cancels because they said they've tested positive, should we ask for proof? And if so, what is that proof? And actually, I know somebody this has happened to, and we think that actually it was just because they wanted to get out of paying and get a full refund. So what do we need to ask for?
Well, that again is very much up to you. If you're going to give a refund because somebody cancels because they've tested positive, then you need to decide, are you giving a refund? Are you giving a full refund, or are you giving a partial refund? Up to what point will you give a refund? And what evidence do you want to see on the basis of giving that refund? So you might say in your terms and conditions that you want to see evidence of a PCR test. And even though that might be something which can be redacted, for example, if the person doesn't want to be giving you personal information, you also need to carefully think about at what point does that kick in if there's a family coming to a property that's a 10 or 8 room property. If gran and grandpa can't come but mum and dad could still come, then does that affect that? But all of this is very much personal choice. You do have to be very conscious of GDPR and not insisting someone give you information which would breach that, but it is possible for people to give you some evidence and redact sections of that which would be inappropriate. But again, at the moment, it depends on how you got the information. Do you have an email address? If so, you probably got an email back. Do you have a text? Did you give them a mobile number? If so, you may have got a text which might have less information in it and be easier to forward. But then do you want a screenshot of that text, or will you accept a forwarded text? Because forwarded text can also be amended. So it's really a case-by-case basis for you to think, how likely do you think this is going to affect you? What steps do you then want to take to protect your business against that? And what information would you accept?
That is incredibly helpful, Jo. I think we're going to wrap up just now, but thank you so much. It's been really, really interesting. And I think the word here is clarity. You've got to be really clear as to what you're trying to say to your guests and what you need them to say to you. And I think, yeah, it's a really important point that if you feel like, you know, you haven't got enough information for today, please do contact Jo. As I say, there is a fixed fee for ASSC members. So when you contact Jo, if you contact Jo, just let her know your membership number, and she'll be delighted to help. But that's been so helpful. As I say, this will be published probably later today, and we'll also publish a transcript so that you can go through it on a piece of paper if that's your preferred option. Thank you, Jo. That's been brilliant. Just to let everybody else know on the call, thank you so much for joining us today. On the 26th of October, we've got our annual general meeting. So we'd love you to join. There will be an opportunity to submit your votes in advance if you can't make the 26th of October. But we're also going to be joined by some fabulous people to talk about destination leadership and the responsible tourism for a sustainable future. We've got the wonderful Willie Cameron, Director of Highlands and Islands Tourism Awards and founding director of COBS, who you may well know from our conferences in the past. He's going to be hosting the event. Then you've got me, and then you've got Kathy Craig, who's the new Chief Executive of the Argyll and the Isles Tourism, Laurie Piper, Chief Executive of Moray Speyside, and Ross Macaulay, also quite new, Chief Exec of the South of Scotland Destination Alliance. So we'd be delighted if you could join us for that. We've also got a new range of, a new programme of talks for the rest of the year. So keep an eye on the ASSC talks page on the website. We will also look through the chat and see if there's anything else that we've missed, and we can pick up on that in the transcription that we publish later on. But thank you all so much for your time, and thank you, Jo, so much for that incredibly enlightening session. Thanks so much, everyone. Bye-bye.
Bye.